panels for you today. First one on the free exercise clause, and then one on the establishment clause. My name is Jim Oleski. I'm coming to you from Portland, Oregon. We've got four great panelists with us today, and what we're going to do is each of them is going to take about 8 minutes to talk about the topic of the day, which, as you all probably know, is the future of the free exercise clause. It feels like we've been having this conversation for 30 plus years about the future of the free exercise clause. It's been a hot topic, but it's particularly a hot topic this year with everything that is going on. I'm going to just very briefly introduce our panelists. I'm not going to try to canvass their remarkable contributions to this field, but just mention one thing about each of them that jumped out at me in thinking about today's panel, and then turn it over to them. So our first panelist is going to be Michelle Goodwin, who has not only written in her scholarship about issues directly going to what we're going to be talking about, the issue of third-party harm in religious liberty cases, a forthcoming piece on civil liberties in a pandemic, but also, as you all know, this conversation is taking place not only in the courts and in the scholarship, but in among everybody in the country. And Michelle has been at the forefront of also sharing information about the implications for civil liberties in a pandemic with the broader public. And that will help inform our conversation enormously today. The second member of our panel is Pam Carlin. If COVID over the last year has been at the heart of a lot of us working through the free exercise clause issues, the other area that's been sort of at the heart of it over the last decade or so has been the intersection of non-discrimination rights and civil and religious liberty claims. And there may be nobody on the planet who has thought more about that in recent years than Pam, having argued the Boston case this summer, in which there wasn't an explicit religious liberty claim at the Supreme Court level, but obviously many of the justices were thinking about that issue. And Pam, I believe, is also one of the counsel for the respondent interveners in the Fulton case, which goes directly to the topic we'll be talking about today. Of course, if there are two other people on the planet who have been thinking about this issue as much as Pam has, there are our next two panelists. Doug Laycock, who has written an enormous amount in the area I just mentioned, the issue of religious liberty claims and other claims, civil liberties claims, but also this summer, as many of you know, the Supreme Court has been working through somewhat unexpectedly in the COVID cases, the doctrinal details of the free exercise clause, and Doug's seminal work from back in 1990 and more recent work that he has done with Stephen Collis have been cited in multiple opinions in those cases. And he also has co-authored a brief in the Fulton case, which I'm sure we'll be talking a lot about today. And then our final panelist, Robin Wilson. A lot of this debate is often at the federal level, talking about the US Supreme Court, talking about federal legislation, and Robin has done a tremendous amount of work in those areas. But a lot of the discussion is also taking place at the states and localities. And I think for over a decade, and Robin can correct me if I'm wrong on that timeline, she has been working also in that arena, most prominently, but certainly not exclusively, in the state of Utah with the legislation that was adopted several years back in Utah. So with that introduction to our panelists, I want to turn it over to them in that order. I will be monitoring the time. Again, they're each going to take about 8 minutes, and we're going to start off with Michelle.
Thank you so much. It's a pleasure to be with you all. COVID certainly has revealed underlying institutional and infrastructural inequalities in our society. And by starting this panel, I'll just give a background that will be filled in then by others that provide greater context for the importance of this conversation. Not all defined by COVID, because there are so many other areas in which life in the United States now overlaps, intersects with how we think about religion. Some have said that religion has become weaponized, or the First Amendment has become weaponized. So in recent years, some would call it a problematic trend, and I've described it as such in writing, has emerged by religion being used to justify harming women, people of color, members of LGBT communities, and even inflicting injury on children. Frequently, those who wish to or do impose harms on others in the name of religion claim an exception by statute, or the Constitution to do so. That is, in some way, these individuals and groups believe they do not need to conform to the general principles and laws of non-discrimination and accommodation in the United States. From time to time, courts condone this type of exceptional conduct. Other times it's rejected, creating a mishmash of law and contradictions within the broader canon of anti-discrimination law. Individuals who desire to turn away, for example, gay men and women from purchasing wedding supplies, clerks who refuse to issue marriage licenses to interracial or gay couples, doctors who deny medical care to children of gay couples, or parents who claim a religious right to pray rather than provide health care for their children, articulate and believe that the First Amendment's free exercise clause tolerates these forms of discrimination and harms. Some people have claimed that the free exercise clause actually grants a fundamental right to cause harm to others. In some instances, those claiming religious constitutional protections for their actions work for the government. For example, you may recall the Kentucky case involving a clerk in Kentucky who refused to issue marriage licenses to gay couples even after the US Supreme Court's ruling in Obergefell v. Hodges, which legalized gay marriage. Her attorney issued a statement noting that Miss Kim Davis, who is an apostolic Christian, quote, holds an undisputed, sincerely held religious belief that marriage is a union between a man and a woman only. In that religious refusal case, the clerk maintained her defiance and her job, despite the fact that the Supreme Court denied her petition to reject gay applicants from receiving marriage licenses. She issued a statement explaining, I am requesting what our founders envisioned, that conscious and religious freedom would be protected. In Alabama, the then Chief Justice of the Supreme Court, Roy Moore, defied the United States Supreme Court after it struck down gay marriage bans. Moore told judges, quote, no probate judge has to issue a marriage license to a same-sex couple for 25 days. Moore's decree may have been more symbolic than anything else, but the message was actually very clear. Moore compared magistrates conducting gay marriages to committing Nuremberg war crimes. He said, say that I was following the orders of the highest authority to kill Jewish people. Could I say I was ordered to do so? And when pushed by a reporter on the absurdity of the comparison, Roy Moore responded, then as Chief Justice, is there really a difference? In North Carolina, more than a dozen magistrates officially refused to perform gay marriages by recusing themselves. The magistrates cited a sincerely held religious objection. In other words, private citizens, as well as government employees and even judges, may hold beliefs that the free exercise clause grants a right or exception to inflict injury on others, particularly if their religious beliefs are sincere. The Supreme Court attempted to address these concerns, at least within the context of gay marriage, in Obergefell. And in that case, the court reasoned that, quote, the Constitution does not permit the state to bar same-sex couples from marriage on the same terms as accorded to couples of the opposite sex, despite their religious convictions. The court made clear in its ruling that, just as we have emphasized here, that those who adhere to religious doctrines may continue to advocate with utmost sincere conviction that same-sex marriage should not be condoned, but they have no right to interfere with others being able to be married. Now, despite the ruling in Obergefell, the Supreme Court, despite that ruling, the Supreme Court has not always been consistent. And we saw that in Burwell v. Hobby Lobby, and at issue in that case was whether the Religious Freedom Restoration Act of 1993, RFRA, permitted the U.S. Department of Health and Human Services to require closely held corporations to provide their employees with health coverage for contraception that violates the corporation owner's sincerely held religious beliefs. And in a sharply divided 5-4 opinion written by Justice Alito, the court held that, quote, as applied to closely held corporations, the HHS regulation imposing the contraceptive mandate violates RFRA. It's amongst these various issues that we'll be unpacking for this particular panel. There's much more to these issues to be discussed, including how parents have been able to utilize, and some would say weaponize, their religious beliefs in order to deny medical care to their children. The results have been literally deadly. There's more to this discussion. I look forward to hearing from my colleagues on the panel, and thank you very much for having me.
So thanks so much also for having me. I will make a confession at the beginning, which is unlike all of my co-panelists, I am not in any sense a scholar of law and religion. I'm a litigator of a number of cases that involve anti-discrimination claims in which issues of free exercise either come up explicitly or are kind of under the surface. So I want people to understand that, given that this is the ALS rather than a litigators conference. I also want to say something about the scholarship, which is that in thinking about what I was going to talk about today, there were two articles not written by people on the panel that I just want to commend to you because you'll see as I give my kind of comments why I think they bear on the issues I'm going to talk about. They're old articles, so you may not have read them if you're a more recent arrival in the academy. The first of them is a 1979 article by John Jeffries and Tom Jackson that was called Commercial Speech, Economic Due Process and the First Amendment. And you'll see in a moment why I think that's relevant to the topic. And the second is a 1990 article by my present colleague, as opposed to my former colleagues, Mike McConnell, on the selective funding problem in abortion and in parochial schools. So I want to talk about three things that I think have changed in law and religion and free exercise that we should keep an eye on going forward. The first of these is the arrival of the complicity doctrine. That is a doctrine in which the free exercise claim is that enabling someone else to do something makes you complicit in their activities. And that's, for example, in Hobby Lobby, what the free exercise claim was really about, which was if you give your female employees contraceptive coverage that includes these particular contraceptive devices, then you are complicit in their in abortion. Now, here's what I think it will be interesting going forward about the complicity claim, which is it's unclear to me what the limits of a complicity claim are. That is, if it's complicity and a violation of the free exercise clause to be required by the government to provide contraception because you believe that would enable abortion, is even having to have somebody on your payroll who has an abortion complicity, because if there isn't funding for an abortion and they use their paycheck to get an abortion, then you're just as complicit. And so I think it'll be very interesting to see how the courts deal with complicity claims as those claims become broader, which I think they will. And part of the reason I think they will is the point that Tom Jackson and John Jeffries made in their article, which was that the failure of kind of substantive due process claims as a way of making liberty arguments led a lot of businesses to turn those into commercial speech First Amendment claims where they found more traction with the court. And so I think you'll see all sorts of claims turned into complicity claims about free exercise. And this is particularly true given how hard it is to challenge someone's claim that this is part of their religious belief. This leads me to the second of the two big developments that I just want to kind of highlight. And that is the rise of free exercise claims by corporations. Traditionally, the free exercise claims were mostly claims by individuals. They were not claims by for-profit corporations. And here I think there's going to be a lot of action going forward. And I'll just give you an example from some of the briefs that were filed in the Philadelphia foster care case, in which I'm a co-counsel for the defendant interveners. But I think even more, this was true of some of the amicus briefs that were filed in the Morrissey Baru case last year at the Court on the Ministerial Exception, which is the question is, for a for-profit business, what turns someone into someone for whom they can raise the ministerial exception? And there were documents in the record there from some businesses owned by very culturally conservative folks who wanted to say, if you have your receptionist offer to give somebody a prayer while she's transferring that person to someone else in the business, then you should be able to claim the ministerial exception, because everything your business does is designed for the greater glory of God in some way or another. And so the question of the contours of the ministerial exception, once you get past what I think are claims where there's a lot of intuitive appeal, religious school teachers, for example, being one of those, regardless of whether they're teaching a secular subject or not, I think you're going to see a lot of action on the contours of the ministerial exception. The third thing I want to talk about is something that was prompted by Mike McConnell's argument, Mike McConnell's article. And the argument there, for those of you who haven't read it, is that there seemed to be something deeply inconsistent in the argument that indigent women's abortions should be financed by the government, but people's decision to use parochial schools shouldn't be financed in the same way. And I want to give the flip side of that, which is, I think, one of the things that you can expect as the court becomes more and more aggressive, which I think it's going to be, in recognizing a set of free exercise claims raised by people who are culturally conservative, is I think you're going to start seeing those same kinds of claims raised by people on the left. And let me give you just a couple of examples of that. One historical one, and then I think one contemporary one. The historical one is one of my favorite briefs to teach to the students in my undergraduate classes is in Loving against Virginia. There was actually a brief filed by the Catholic Archdiocese in the South arguing for a free exercise argument as to why Virginia's prohibition on interracial marriage was unconstitutional, which is, they said, in our church, any two believers, of course, today we would say any two believers who are not of the same sex, but any two believers should be able to access the sacrament of marriage. And by not allowing us to perform Catholic interracial marriages in the South and have those marriages be treated as valid, you're interfering with our free exercise claim. The contemporary example that I want to give you is, I think if you think about what some of the major projects of the current Supreme Court are, I think one major project is this expansion of free exercise claims on the part of culturally conservative individuals and businesses. But the other is a deep suspicion of affirmative action and of anti-racial subordination arguments. And I want to ask just the following question, which is, think about what happens when a private business or a private university makes the following claim. Our deeply held moral, religiously motivated views lead us to think that we have a duty to combat the racial subordination that's been historically true in America. If you have gone to any of the temples that I've belonged to in my lifetime, synagogues I've belonged to, they all have a deep commitment to racial justice. And so the question whether that will turn out to be a defense to all of the claims that are brought by people challenging race-conscious affirmative action. Or think about the claims in the abortion context. If the Supreme Court were to overturn Roe against Wade or to nibble it down even further, what do you then do with a woman who says, my deeply held religious belief is that I am not in a position now to bring another child into the world. And my religion tells me under those circumstances, the most moral thing for me to do is to terminate this pregnancy, either because I can't take care of this child or because this child has an uncorrectable defect that will lead, if the child is brought to term and is born, to a deeply painful life. What happens then? Because I think that has not been on the forefront. But one of the things actually that the hopeful part of yesterday, as opposed to the appalling part of yesterday, was the election of Reverend Warnock to the Senate, which reminds us that there is a large cadre of people of faith on the left who will make the same kinds of claims, and watching how the Supreme Court will deal with those claims, as well as the claims of people with whom a number of the justices seem more sympathetic, will be very interesting to watch in the years ahead. Thanks.
Thank you very much, Pam. Doug?
Well, it's good to be here. I want to do a quick review of a bit of history and then do a little bit of doctrine. The politics of free exercise have changed a lot over the last generation. Free exercise is a fundamental human right. It was part of the civil libertarian agenda. The Reagan Justice Department hammered at it for 8 years, filing briefs over and over to minimize free exercise. They thought enforcing the free exercise clause was a classic example of judicial activism. Employment Division versus Smith, which cut back on free exercise, was the work of 4 conservatives plus Justice Stevens. Brennan, Marshall, Blackmun, and O'Connor rejected the change in doctrine. Souter pretty clearly rejected it at his first opportunity in Lukumi. Breyer expressed serious doubts about it at his first opportunity in Bernie. The Religious Freedom Restoration Act was enacted by an essentially unanimous coalition from left to right. What opposition there was came from the right, from the pro-life movement, and from prison officials. I testified at the time, and the president of the ACLU, Nadine Strawson, testified at the time. Look, churches are receiving these demands that they have to change the rules and practices on gay rights. That's the reason why conservatives need this bill. That argument got emphasized precisely because the opposition was coming from the right. The conflict between religious liberty and other civil rights mostly dates from the late 90s, and it changed the politics. It was in the late 90s that the conflict between gay rights and religious liberty began to emerge in a serious way. The gay rights cases and the contraception cases have deeply divided the court. They have gotten nearly all the publicity. In some ways, they are atypical cases. They are certainly important, but there are lots of other cases out there that are much less controversial. And other cases sounding in free exercise have been unanimous in the Supreme Court. Gonzalez v. Ocentro on using a hallucinogenic drug was unanimous in 2006. Hosanna Tabor on the ministerial exception was unanimous in 2012. Holt v. Hobbs on a Muslim prisoner wearing a beard was unanimous in 2015. So, the liberal justices are not hostile to free exercise, although the COVID cases suggest, they're less enthused or more suspicious than perhaps they used to be. But mostly what's going on, what's dividing the court is what kinds of interests are sufficiently important or compelling to override a prima facie free exercise claim. And each side has its list of things it cares about, but the things the liberals care about most have been the most litigated recently, and they care more about gay rights. They cared more about contraception than they did about religious liberty. The conservatives have their own list. But when those countervailing issues are not a major part of the case, free exercise decisions are still often unanimous. The conservative justices are no longer opposed to judicial activism. That was the opinion they wrote in Smith. But now they have the power and they mean to use it. I think that's mostly a bad thing, given what they're going to use it for. It's going to partly be a bad thing in free exercise because they're going to carry it too far, but I think it's a good thing that we will get serious protection for free exercise again. The Smith opinion itself is deeply ambiguous. Scalia wrote memorably and flamboyantly, but not always clearly, and especially not clearly when he was cheating like hell on the precedents, which is what he was doing in Smith. So Smith is largely written in the negative. It tells us over and over what the rule is not. There is no very clear statement of what the rule is. And the key concept in the opinion, neutral and generally applicable law, is nowhere defined. I said at the time that the opinion could turn out to be broad or narrow, depending on what the court did with, I counted 7 exceptions to what was stated to be the rule in Smith, including what seemed to be a reasonably clear statement that a law with secular exceptions would have to also have religious exceptions, or a compelling reason why not. The conservative justices have now picked up that idea and are running hard with it and are in some ways misusing it. So the 2 COVID cases over the summer are very illuminating. I actually think they're both wrongly decided, one in each direction. The Nevada case earlier in the summer, when Justice Ginsburg was still there, and when the chief sided with the liberals, um, in the Nevada case, churches were subject to very tight restrictions, and casinos were not. Um, in terms of COVID, casinos are just as dangerous as churches because people sit there together for a long time. Um, but the chief was prepared to defer to the state in a medical emergency. The liberals apparently were as well. And they really didn't have much of a rationalization for the treatment of casinos. They just said, look, this is an emergency. The Brooklyn case in the fall, after Justice Barrett signed on, goes in the other direction. The court said, look, you treat retail stores better than you're treating churches. Well, people don't sit together for an hour and a half in retail stores. They don't linger in retail stores. The danger there is not the same, but the 5 of the conservatives latched on to the treatment of retail stores to say there's discrimination here against churches. As the doctrine had developed, at least before the Brooklyn case, it's not just any secular exception that requires a religious exception. It's a secular exception that undermines the state's interest to a similar or greater extent as a religious exception would. And I don't think the Brooklyn case qualified for that. So that's one path of development, to exploit the exceptions in Smith, and it's been the dominant path so far. But 4 justices in an opinion accompanying a cert denial a year or so ago invited reconsideration of Smith. And in the case Pam is involved in, Fulton v. City of Philadelphia, the Beckett Fund has, 1, made an argument that there's no neutral and generally applicable rule there, and 2, that the court should overrule or reconsider Smith. It's pretty clear just from the size of the conservative majority now, the religious claimant's going to win that case one way or another. I think it's impossible to predict whether they'll say there's no generally applicable rule. The city could easily create a generally applicable rule on remand if it hasn't done so already, or whether they'll take this occasion to overrule or redefine Smith. The narrower course, the more judicially conservative course, is to decide within Smith, but it's readily foreseeable that that's a short-term decision, that if there's no generally applicable rule about foster care placement in Philadelphia now, there will be after a remand. They may take this occasion to rewrite Smith. I think Kagan and Breyer could be votes to rewrite Smith and then find a compelling interest in prohibiting sexual orientation discrimination in pretty much every context, including placement of foster children, which is what's at issue in Philadelphia. If it doesn't happen in Fulton, there's another cert petition in the works in a New York case called Roman Catholic Diocese v. Vullo, where New York requires all health insurance policies to cover abortion, and there's no exception for employer-sponsored policies by the Roman Catholic Church. There's a diocese involved in that litigation. It's much harder to find an exception there. That looks like a generally applicable law, and that may force the issue on the future of Smith. Just speaking briefly about the examples that Michelle mentioned and that Pam foresaw, I think some of them, the free exercise exemption is quite defensible, and some of them is clearly not. And I do think the court is likely to go too far. Justice Alito's opinion in Hobby Lobby says you just got to take the church's word for it when they say there's a burden on religion here, that there's a burden on religion. We can't review that. That's not going to be sustainable in the long run, but it may last for a while given the current majority. There has to be some capacity to draw lines and to say, this may be a burden on religion in your understanding, but it's just too attenuated to count as a substantial burden for legal purposes. And then what counts as a compelling interest is obviously the other line of combat in these cases. And I certainly agree that no one in the name of the religion has a right to impose serious harms on non-consenting others. That doesn't mean no harm at all or no impact that the other person can define as a harm. No other constitutional right is required to be absolutely cost-free. And in some of these cases, the harm to the religious claimant is considerably greater than the harm to the person on the other side of the transaction. In Masterpiece Cake Shop, I understand the insult and the offense to the couple, but they're still married, they still love each other, they still have their jobs, and they immediately got another wedding cake for free. The baker has had to choose between his conscience and his profession. He's lost 40% of his business because he doesn't do wedding cakes for anybody anymore. And that's not a one-time event. That's a permanent loss for the rest of his career. So it's not enough to identify some harm on the other side. We've got to compare the harms between the two sides. I filed briefs urging the court to say protect same-sex marriage and then create religious exceptions. I think we can protect both in the great bulk of cases, and I think that's what we ought to be doing.
Thank you very much, Doug. Robin.
Guys, give me just half a second and perhaps a little bit of grace. I'm filling in, you might know, either for Michael or Usma or somebody. So I'm going to just give you a 2-day take on what I think is the future of free exercise. In typical law professor fashion, I'm going to be adjacent to the actual topic. What I was sort of interested most in is what's likely to happen with the Trump legacy after the Biden administration comes in place, and how hard it will be to sweep aside what the Trump administration has done. So you'll remember that they kick off by rescuing the Little Sisters of the Poor. I'm going to come back to some of those regulations in a minute. Want to just say at the very front, I don't have any problem with the Little Sisters of the Poor. I just think that a lot of what the Trump administration has done in order to rescue them and to protect the rights of religious believers has been incredibly overbalanced. And I think that that means that there will be things swept aside where in previous administrations there might have been actually very broad-based agreements. And I'm going to give you an example of that, like beneficiary choice, in just a moment. So my problem isn't any problem with the sisters necessarily. What I think is really happening, the sort of elephant in the room that we're not talking about, is the actual positive law. And here I mean mostly regulation at the administrative state level, but not only that, we're going to see that at the state level. And Michelle's already talked about some of it, the vaccine exempt. Actually, everybody sort of touched on some of that to some degree. If I have enough time, I'm going to try to talk about some of what's come out of the Office of Civil Rights and HHS, including the waivers for foster care, which did not have protective devices for other interests the way that Doug is talking about balancing. And if there's any time at all, I'll talk about the positive law and how it's changing around the vaccine exemptions for religious believers and people with philosophical exemptions, and then a new emerging trend to actually have vaccine mandates. So real quick timeline, you guys will remember all of this, but we have not only the Trump exemptions to the contraceptive coverage mandate, but then we had a one-off waiver for Miracle Hill, which is the adoption agency that receives Title IV monies that turned away not only same-sex couples, but Jewish couples, Catholic couples, all kinds of couples that didn't have their particular view of Jesus. And they receive an exemption to do that. Sorry, I can't see all these timelines because of the way I'm sharing, but just trust me, there's more going on in here. And then we have the Section 1557 non-discrimination rules. Now, there's a lot more coming out of HHS and OCR in particular. Some of it may or may not be controversial, like the work that they're doing around data privacy, for example, or healthcare IT. So I'm not really particularly concerned about that. What I'm concerned about are those things that have this valence around religious liberty. So let me go back for a second and make a few contrasts. And this is all just a recap, I'm sure, for everybody in this room. But the contraceptive coverage mandate immediately inflamed, people about whether they would, at least with 4 of these drugs, be somehow facilitating an abortion. The FDA labels themselves suggested that these drugs might work on the implantation site. And on the way up to Hobby Lobby, that factual question was stipulated too. That it possibly would. That, of course, inflamed all kinds of religious believers who said, as Archbishop Lori says here, you can't make me, a religious believer, violate my conscience. These are complicity claims, as Pam said, in order to facilitate your access to this type of thing. And then Obama actually responded in a very measured way to the pushback from religious nonprofits in particular by saying not only would women be able to access these drugs with no hassle, no copay, no wait, but religious providers wouldn't be forced, at least the religious nonprofits, to pay for this directly. And as you'll remember, he dragoons a federally facilitated exchange to ensure to pick up that slack for women. And then we have the Trump fix for this particular clash, which was, and we see in the Little Sisters of the Poor decision this summer, was to basically punch a hole in the ACA coverage mandate, a wholesale exemption for any religious objector, and to punch a second hole in there too, a moral exemption. And what's different from the Obama approach is that no provision was made on the backside of that for the access of women. So there was no intermediating group that was going to pick that up. And this continued in parallel with the Obama fix. And objectors were permitted to pick between one or the other approaches, as opposed to, making sure that women had some sort of access. And then this, of course, gets sustained over the summer in a decision, but a 7-2 decision, a decision written by Justice Thomas, in which he basically says, well, as a matter of statutory interpretation, HHS had the right to come up with this coverage mandate. It was given the authority to do that, and it can punch holes in it too. Now, query whether anybody is going to try to sustain any of these regulations given how overbalanced they are in one direction. And that's a little bit different than what we see in the final conscience regulation also coming out of HHS. Here, we had little pockets of conscience protections that Michelle and others on this call and Doug have written about extensively, the Church Amendment about abortion and sterilization, other conscience protections connected to certain buckets of money around end-of-life care, for example. And it's as if they get stitched together to have a massive conscience overlay purporting to tell healthcare providers that if you just, don't feel like you want to do a particular thing, you don't need to do that. One set of critics talked about this conscience rule as just stirring up a hornet's nest of controversy. I've been critical of it because I think it's textually unbounded to things like the Church Amendment. It's far greater than what the net that was cast by Congress was. Now, continuing also out, we have the way in which they've been treating Miracle Hill, giving one-off exemptions or waivers from Title IV's non-discrimination rules. To this group that really was not making referrals elsewhere, wasn't doing things to make sure that couples that wanted nothing more than to adopt or foster a child were able to access that. I'm actually an adopted child myself. I mean, this is mind-boggling to me. We have 407,000 children waiting for families, and we're allowing these folks to say no and make no provision for someone else to pick up that. And I think that's one of the problems about third-party harm in this space. I think there has to be an absolute referral duty in order for these things to be sustained. And I think Doug agrees with that too, but I'll be interested. Now, in this context, like we've seen in others, and we'll see in Section 1557 in just a moment, we're basically seeing dueling claims of discrimination. You've almost heard that across this panel to some extent in terms of the emphases about who's being harmed most here. One of the things that's been distressing to me in particular, as an adopted child, as somebody who was fostered, is the way in which we're splintering across the country, where some states are saying, no, we're going to have a SOGI non-discrimination protection, not so much concession or concern about what is happening to those religious providers and to the marketplace if religious providers leave. And then on the other side of that, religious providers saying, hey, no. And in many of the early state laws across the country, there's an affirmative duty to refer. One of the things most distressing in the last year is that Tennessee has an adoption foster care rule that permits agencies to say no. And as I understand it, there's no referral duty in that law. And I think that should give us pause. We're seeing back around Section 1557, there are LGBT persons who have been denied care across the time of the Trump administration. That has been protected in new regulations out of HHS. Those are still, I believe, in the time frame where they could be undone. I'll show you that in a moment with the Congressional Review Act. But again, dueling claims of discrimination. One side saying, you know, I'm entitled to this because it's sex discrimination, very much a stronger case after Bostock, and the other side saying, no, I don't have to do this because of the Church Amendment or the HHS regulation or whatever else it is. One place that I think is going to be very tragic is what has happened recently with beneficiary choice. Beneficiary choice in the Bush eras, right, and the Clinton eras, during the time of Obama, they always had the idea of religious people working in parallel with secular people to meet the needs of ordinary people for services. And we do need all hands on deck, especially with things like foster care for children. But the new beneficiary choice rules, as I understand them, are saying that there can be a religious only provider without another option. And I think that's deeply disturbing. Now, look, beneficiary choice has had broad acceptance across all of these different administrations, including the Trump administration. It's been explained as maximizing parental choice. It's been justified in terms of providing a full range of providers. You know, Obama talked about it as a matter of, accommodating people and their family. This was, of course, the Child Care and Block Development Program. But it is subject to those beneficiary choice rules. And right now, the state could just be like, yeah, I'm only going to have religious providers, and it doesn't matter that the beneficiaries might not want only religious providers. And that's problematic. Now, I think we're going to see all of this stuff get wiped clear because it's so overbalanced. Unlike, for example, some of the things that came that were considered at the end of the Bush administration by the Obama administration.
Robin, can I
go?
apologize for interrupting. Can you
Yeah,
wrap up?
that's fine. Yep, no problem at all.
Right.
And sorry again, I'm filling in. I'll just make this one point. We're watching on the vaccine exemptions, the country change in real time. And we're also seeing mandates lay on top of those. And I think the mandates are going to put a tremendous amount of pressure on the exemption picture as opposed to just itself. Sorry about that. Again, I'm filling in, so I didn't mean to monopolize.
Great job. Thank you to Robin and to everyone. I actually want to take moderator's prerogative because Michelle, you were very good and went well under your allotted time. So I just want to, before I start taking questions from the chat box, give you the first crack at responding to anything from any of the other panelists.
Thank you so much for that. I try to be on time. Here's what I want to say, which is that, the area in which we're talking about reflects a mishmash of law that comes from the state level, the federal level, and also from our courts. And it's not well sorted at all. And there's much work to be done in this area in terms of giving clear, what one could say, academic guidance in this domain. From what Erwin Chemerinsky and I have written about in this area, where we have said that the free exercise of religion, whether it's pursuant to the Constitution or a statute, does not provide a right to inflict injuries on others. One person's freedom ends when another person will get hurt. And one doesn't want to be reductive or simplistic, because I take quite seriously the arguments that are made by Doug. I think that there are lots of areas in which we agree quite a bit. But one person's freedom does end when that other person gets hurt. And, and this is not an anti-religious approach, and it does not deprive free exercise of religion any kind of meanings. People still can believe what they want and worship as they choose and follow their religious precepts until and unless this would hurt someone else. Now, this requires nuance. And of course, I'm speaking in broad strokes here, but the types of issues that we've talked about that relate to people's dignity and that fundamentally relate to their health have been used to encroach upon them being able to pursue what have been otherwise articulated as constitutional rights. And we could talk about that within the context of healthcare, let's say, abortion rights. But we could also talk about it and other areas, including what Robin just was talking about, not so much that involving adoption, although very important there, but just in terms of talking about parents being able to exercise religious choice to the degree that it may result in their children's death. And so let me just close out this moment that you've given me with the following, which is that a few years ago, Dr. Paul Offit wrote a book about children who suffered or died because their parents preferred to pray rather than provide medical care for their children. And towards the end of the book, he quotes a study that found that 23 denominations in 34 states practice faith healing, and that tens of thousands of Americans were refusing medical care for themselves and their children. The study found that 172 children who had died with a strong likelihood that the denial of medical care because of religious reasons or religious arguments made by their parents actually led to this lack of treatment. There's no actual way to measure the number of children who've actually suffered or died because they were denied medical care based on their parents' religious views. But it is to say that if we, disentangle this area, we'll find more than the LGBTQ space, the cases that involve abortion, the cases that involve adoption. And we'll also see some of these other cases that are worthy of thinking about in this space.
Thank you, Michelle. We had just a quick question for you from the chat. The name of the book that you referred to.
Let me pull that up for you. I'll put it in the chat.
Wonderful. And then great. I'll share it on the public chat if you're on the internal chat. So I'm going to just relay some of the questions we've gotten from the chat to the panelists at this point, and folks who are on the public chat, feel free to continue adding your questions. The first one goes back to a comment we had earlier in our discussion about religiously affiliated schools and whether it should make a difference that some schools have become maybe less religious and more secular over time. I think about I went to Georgetown Law, and my perception, and it could be wrong, but my perception is that the amount of religiosity, at Georgetown Law differs from Notre Dame, and that at Notre Dame may differ from Ave Maria. Does that play into the analysis? Should that play into the analysis? Any of the panelists want to take a crack at that?
Yeah, that clearly plays in, although again, it's hard for the courts to deal with. The differences are much clearer at the university level, right? Harvard was founded to train the clergy, but no one thinks Harvard is religious anymore. At K through 12, for a long time, the court sort of had an image or a stereotype of what K through 12 religious schools were, and it wasn't always accurate, but they didn't inquire too much into the facts. There are cases in an analogous context, the explicit Title VII exemption for religious discrimination in employment, and some schools have been held no longer sufficiently religious to qualify for that. It doesn't come up very often, but it does come up, and I assume it will come up in ministerial exception cases. With the Trump appointees, anything is possible, but I would be surprised if any secular business succeeds with a ministerial exception claim. I don't think it makes sense in terms of the origins and context and contours of that doctrine.
Thanks, Doug. Anybody else?
If I could just jump in, I agree with you, Doug, that I think on the ministerial exception, that's exactly right. But I'm not sure what that means, for example, for a challenge to Georgetown Law School having a race-conscious affirmative action policy,
right?
Which it's not a claim about the particularity of somebody's job, where I think it's impossible. And I think ultimately the court is not going to hold that the janitors at a religious school are engaged in the ministerial exception because they pray once a day, or at least I think some justices might vote for that, but I don't think most will. But when you come to things like a Jesuit school saying it's part of the Jesuit mission to break down racial barriers, I think there it's going to be much more difficult for the court to say, well, we will allow, we'll allow the parochial schools that are connected with a Roman Catholic archdiocese to do this, but we're not going to allow Georgetown to do it. And I think that's where there may be some real play in the joints.
Yeah, I agree with that. Because their jurisdiction is pointing to a specific doctrine it's acting on in the facts of this case. It's not relying on its general status as allegedly still a religious organization to get a more
Exactly.
generalized exemption.
So our next question, actually, Pam, is I'm going to start with you and then open it up to others. Goes back to the affirmative action example you raised, and there was a question from one of our participants about how the race is different argument that is made with respect to the slippery slope arguments that are made in some of the cases where religious exemptions are claimed from civil rights laws, and the argument is, oh, it wouldn't allow refusals of services to interracial couples because race is different, how that might play into the affirmative action example that you were talking about, or whether you think it does.
So one of the things is, if you're talking about a lot of modern anti-discrimination statutes to which people are claiming exemptions, the statutes treat, that is, the government has made the judgment that these forms of discrimination are exactly equivalent. So if you have a statute that says you can't discriminate on the basis of race, sex, or national origin, or sexual orientation, having somebody come in and say, well, the government has a really compelling interest for one of those and not for the others, it is a little bit of a heavy lift. I mean, it's not impossible, obviously, for the court to say race discrimination is different, but then what do you do when someone comes in with a claim about affirmative action connected with sex discrimination? For example, traditional, a public employer or another, well, not a public employer, obviously, because they can't have a religious claim, but a private employer that has an affirmative action plan to bring women into traditionally male jobs at the company. Do you say, well, that's not really compelling either, and therefore you can't claim a religious exemption from that law? I think it will be, it's not that it's impossible to do this, but the other question is, at some point, does culture change in a way that these forms of discrimination are seen as sufficiently similar, in which case the exemption has to be applied to all of them or to none of them?
Thank you. Others who want to get in on that question?
Just add here that Pam offered, I think it was you, Pam, offered the example of the amicus brief that was filed in the Loving case from the Catholic Archdiocese. What's interesting there is that religion has also been used in a weaponized way towards racial discrimination. Historically, to justify slavery or even some of the ordinances during Jim Crow, religion was involved. I mean, even in the defense of laws that would forbid interracial marriage. The thought was that religiously it was always intended. And of course, not everybody believed this, as the Catholic Archdiocese didn't, but there were those that did make arguments that that historically, within the context of religion and making arguments connected to the Bible, that races were never meant to mix together, and that furthered certain claims that interracial marriage would result in offspring who would then have physical disabilities and other kinds of disabilities. But many of these arguments had some religious grounding. So that's what's also interesting within this space. Now, of course, that has nothing to do with the free exercise of religion necessarily, but more generally, when we're talking about religion, religion has been used in weaponized ways that connect with racial inequality and discrimination.
Doug, you looked like you wanted to get in as well?
Well, I do think race is constitutionally different. What counts as a compelling interest is not a statutory question. It's a constitutional question. And the court can draw lines within statutes between things that a legislature lumped together. And I don't for a minute minimize the history of discrimination against women or gays or ethnic minorities. But no one else has the history of slavery, and resolving these other forms of discrimination did not require a civil war, 750,000 deaths, and 3 constitutional amendments. And I think, and we're still struggling to enforce those amendments today. I think courts can say race is special, and there's always a compelling interest in protecting the African Americans. And then in terms of Pam's hypothetical, that gets you directly to the affirmative action debate, and the conservative insistence that affirmative action is just as bad as historic discrimination against Black people. I don't agree with that. I don't know if they would go there in the context of a free exercise claim or not, but I think that would be how the argument would play out.
Did you want to weigh in, Robin?
Yeah, I'll just make maybe 2 points. But one is the compelling interest in Hobby Lobby, as I read it, was a compelling interest in the state in not exempting the religious objector. And so I think, for some things, we can allow the religious objector to step off. We saw that Obama did that specifically. He just found another device to make sure that the good that they were trying to get done got done. And I think in other contexts we can't. And I think it's very fact dependent and fact bound. So the idea that it's all for, both of these things get treated in the same way or not at all, I think that might be generally, but I think the question is whether the state can afford these other interests to be put to the side and still accomplish the thing that it's trying to do. So that's one point. Second point is that I think we have made tremendous social progress in the context of extending civil rights when we've been willing to just, let some pieces lay low and stay to the side. If you go back and look at the Civil Rights Act, we regulated in 4 narrow silos. It was far easier to get an answer about those 4 narrow silos that we all could get behind than to level everything. I think the problem now is not only the size of the administrative state, that you have all kinds of things being encompassed, and as more and more things are encompassed, there are going to be other interests that are implicated. And that goes to the point that Doug has made about weighing harms and trying to think about that. I think one of the things that is really sad about this whole space is that we are not trying very hard to have it both ways. We always go to the court. The court can only give us win-lose answers by and large. They're not a super legislature to type what people think. And so they can't fashion an answer that can make both interests or both sides or all sets of people well at the same time, the way that Congress can. And that's most pronounced and acute in Fulton. In Fulton, with children who are awaiting foster care and adoption, we can neither afford to have loving couples sent away in a humiliating fashion. If you had done that to my parents, for example, my father would have said, Alice, we are out of here. And that would have been the end of my sister and myself being adopted. You just can't, the religious right undercalculates the cost of that. On the other side of this, you cannot wipe these religious adoption placement agencies off the face of the earth. If you do, that you have no hope of placing these hundreds and hundreds of thousands of children. So you need an all hands on deck answer. And that is the kind of answer that legislatures can give. It's the kind of answer that Azar could have given instead of the straight up, adoption exemption that they have and foster care exemption that they proposed, which will go nowhere. But in any event, it's tragic. I think we should stop for a moment and notice how tragic it is when we're just saying this team or that team should win.
I'm going to come back to the Fulton case in a second. I just want to, because we are going to run out of time before we get to all questions, do 2 things. One, make a comment for everybody's benefit. Pam had mentioned earlier, I think it was Pam, and I apologize if it wasn't, the substantive due process issue and the relationship between free exercise claims now and people viewing them as similar to past substantive due process claims. And for the benefit of folks who are watching who didn't get to see this yesterday, the Federalist Society hosted a debate between Eugene Volokh and Michael McConnell. And if you're interested in this issue, they actually debate this very issue. Eugene taking the position that the court should uphold Smith and reject the secular exemption requires a religious exemption view based on the argument that it looks like substantive due process. And Michael making the contrary argument, no, this is an enumerated right. It's fundamentally different than substantive due process. So if folks are interested in that argument, just wanted to flag that I presume that video is out there. I do want to jump ahead to one of the most recent questions in the chat. Michael Moreland has asked, and since the topic of our panel is the future of free exercise, he asks, if the city loses in Fulton, and there's obviously an assumption there, but if the city loses, what basis do you think it is going to lose on? Michael is not, it doesn't seem confident that the court's going to overturn Smith, but maybe some of you are. How do folks feel like that case is most likely to turn out? And feel free to say you think, the city is not going to lose. Who wants to jump in first on that?
Well, Pam's in an awkward spot, but she's the one actually best suited to answer this question. The facts in Fulton are unbelievably complicated. And the plaintiff's claim is the city has tried 6 times to explain how it has a rule here, and none of its rules actually apply. And I am not the master of those facts. I did a brief on overruling Smith. The facts are a mess. The city's in an awkward situation. It may well have a rule that applies, but I'm not clear what rule it is. I think the court is most likely to say whatever rule there may be here is not generally applicable, but it could well overrule Smith. I don't think that's the most likely outcome, but I don't think it's a very low probability outcome either. I think it's a plausible possibility.
Pam?
I represent clients here.
Oh,
It's not
gotcha,
really
sorry.
something I want to talk about. Sorry.
Robin or Michelle, either of you want to weigh in?
No, I think that the intuitions that Doug has already shared about it are point on. I think we have to see what's going to happen. It's not exactly clear.
So another one of the questions we got in the chat involves some cases that just happened recently. Actually, I think it's the Supreme Court's most recent decision in one of the COVID cases, the Danville Christian Academy case, in which they, on prudential grounds, declined to issue an emergency injunction to schools that were bringing the free exercise claim there. And then more recently, a Sixth Circuit decision. Both of these cases that I'm referencing, one out of Kentucky and one out of Ohio, involved the closing of schools, both religious and non-religious. In Kentucky, it was K-12. In Ohio, it was Lucas County. It wasn't statewide. It was just in Lucas County, and it was grades 7 through 12. As I mentioned, the Supreme Court didn't reach the merits in the case that went up to them, but the Sixth Circuit did, in a decision that came down last week, say that the religious schools bringing the challenge had a right to reopen, notwithstanding the county's order shutting down both religious and non-religious schools. And the essence of the decision was that it was discriminatory against those religious schools because other non-religious entities, bars, casinos, grocery stores, what have you, are open in Lucas County, and schools are shut down. And so I was wondering if the panelists might be able to weigh in on that. And let me just go in the order that we originally presented. Michelle, do you want to be first to go
Sure.
talk about those
Sure.
cases?
Well, these areas that involve COVID and COVID-related restrictions are a bit complicated. And here's why. For the most part, courts have relied on Jacobson v. Massachusetts as the leading case, 1905 Supreme Court case, that gives rise to the permissibility of mandated vaccines. It speaks to parents' patri authority of the state to be able to use its authority to impose some restrictions on people in order to protect the public health and safety of the greater good. These kinds of laws actually date back centuries to the 1300s, 1400s, 1500s in Europe before we ever existed in the United States. But this has been basically the foundation for how we articulate in this health space. And during this pandemic, it's become quite complicated because it's been 100 years since we've had a pandemic in this country and have had to address these unfolding types of issues. And this is one of the key areas, and that I guess speaks to my opening remarks of religion perhaps being used and weaponized in distinct kinds of ways. Because why in the world should there be an exemption, especially given in this case that there could be the harms that children and teachers experience? At the same time, one has to be mindful of the argument as making some sense. Why exactly are the bars open? Why are some of these other areas open if we're going to say that we're actually protecting public health? So, what that is actually exposing is that there has been inconsistency in how governments have responded in these areas since COVID. They're interested in making sure that bars can stay open to generate an economy. And in some ways, they're trying to appease certain parts of a community. And one of the biggest problems that we see is not necessarily the free exercise issue here. And it's not exclusively a public health issue, although that's what should be driving us here, is that we see a failure to actually address in a comprehensive type of way the pandemic itself. And I know that's slightly off point, but it actually is quite on point. And it gets us to where we are today, where there are some businesses that are open, some things that are not happening. It's been a failure to actually address comprehensively how we deal with a public health crisis, which then could perhaps help us in terms of how we articulate in a constitutionally robust fashion what exactly should be in terms of people's responses to COVID, and how can government impose certain restrictions without imposing unduly restrictions or undue restrictions on people.
Thank you very much, Michelle. Pam?
So I don't have a lot to add to that. I'll just say that the question of what the comparator is for the religious claimants is, it is a kind of fundamental question in law generally, right? Which is a parochial school more like a public school, or is it more like a bar? And if the argument is that kind of most favored nation status for a religious claimant, that is, if anyone gets this in any form, no matter how unlike a religious claimant that that preferred category is, that way lies madness at the end of the day. Because if there's any unregulated business, then a religious business has to be given the same level of unregulation, even if one of those businesses is an auto repair shop and the other one is Hobby Lobby. I don't know how you run a legal system once you get to that. That is a place where the comparator just has no clear connection to the religious claimant. But I agree with Michelle that everything that's been done on COVID has been done on the fly. And having everything done on the fly, there often are these odd comparators. Now, obviously, you can come up with explanations for the bar versus the school. And then the question just is, what level of scrutiny are courts going to give to those? Are they going to treat this as if this is pretextually designed to disadvantage religion, or are they simply going to treat this as maybe not the best thought out and therefore valid, even if not particularly well thought out distinction?
Thank you, Pam. Doug, let me just add one thing before I turn it over to you. The question also asked, and I neglected to mention it, are these cases potentially examples of where establishment starts to come into play as well, which we haven't talked as much about, and obviously the next panel will be talking about. So with that, let me turn it over to you, Doug.
So the COVID cases are special in many ways. Governors and mayors are doing these regulations on the fly. They're trying to deal with the whole economy and really all of human behavior, sometimes even inside the home, but certainly everything outside the home. And so it's very hard to get the regulation right. And then the cases are all being litigated on an emergency basis on motions for a preliminary injunction. What we really need in these cases is some medical evidence about the relative danger of whatever the church or the school wants to do, and the relative as compared to whatever's being allowed to be open. There are affidavits to that effect in some of these cases. There is nothing but lawyers' intuition in many of these cases. So they're being litigated in a half-assed way and regulated in a half-assed way because of the emergency nature of what's going on here. And as I said initially, I think the two that have gotten to the Supreme Court, they got them both wrong and they went in opposite directions. Pam's point, what's the relevant comparator, is certainly the key point, and there is a standard in the Lukumi opinion. It's an exemption that endangers the state's interest to the same or a greater degree. That's not absolutely anything that happens anywhere in the economy, but it doesn't have to be directly analogous to a church. And in Lukumi, they looked at all sorts of state and local laws on the treatment of animals, and even on things that weren't about the treatment of animals, but pose the same kinds of sanitary dangers that the city was alleging. The two school cases in the Sixth Circuit present the question with unusual clarity, because the secular private school and the religious private school are treated exactly the same. And if you ask the question, does this look like discrimination against religion in the way we have typically understood discrimination in other contexts? The answer is no. But if you ask the question, does leaving the bars and restaurants open create as much danger as leaving a school open? Probably creates more. I'm on the board of a private school. I've been looking at this kind of data, and schools are not a principal vector for the spread. So what's the relevant comparator is the key question. I do agree, if we create an exemption for religious private schools, there has to be an exemption for secular private schools. You can't discriminate between the two of them. I don't think the same thing follows for closing the public schools and allowing the religious private schools to be open. Those two don't have to be treated the same, because the distinction is public-private, not religious secular, and the state can do what it wants with its own schools.
Thank you, Doug. Robin, we're down to our final minute, so you're going to close us out.
Okay, well, Nelson, I was just going to say what Doug said, though. If you allow the parochial school to meet, you're probably going to have to allow the non-religious school to meet. I'll make one meta point. I think a lot of folks believe that the difference from the early COVID case to the last was the Justice Barrett effect. I don't think that's really what's happening here. I think, in fact, what's happening is we have a longer expertise and experience with these rules. We've seen governors sort of play cat and mouse with rules and changing them on the fly. They're not only changing them on the fly, but then when they get challenged, they are withdrawing some of the rules, and it's hard to get clarity. And I really think what's happening over time is that the people charged with protecting us have not had the luxury and have not taken the time to try to explain the public health bases for these rules. I'm not going to disagree with some of the comparators. I will say that when Caesar's Palace is flush and full of people, and it looks like a hotbed, of disease, and right next door is an empty church, that's a problem, right? And if they were trying to explain why they were picking one comparator as a matter of public health data versus another, I think these things would work out differently. I think there's been a kind of glibness about that, like they didn't need to do that because, damn it, they're trying to get the economy back online, and religious people, that's not so nearly important. And we do know that there's actually a real literature about how being able to worship at a time of great stress is actually very helpful to people for their mental health, for their physical health, for grief, and all kinds of other things that Americans are struggling with. And I think those kinds of less tangible, non-economic benefits of worship aren't even playing in all of this space. And I think they would have to be considered as well. Is that good?
Thank you, Robin. Well, thank you to the entire panel for a great discussion. Just everybody watching, there's going to be, I think, a 15-minute break, and then at 4:15 Eastern, 1:15 here on the West Coast, the Establishment Clause panel will begin. Again, thank you. It was a wonderful conversation, and see you all soon.